Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention. You shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Welcome to the Florida Supreme Court. Our first case for the day is Poole versus State of Florida. You may proceed.
May it please the court, I'm Steve Bulletin from the Public Defender's Office in Bartow. I represent the appellant Mark Poole. There are 4 case-specific issues in this case. I've only got 20 minutes of argument, so obviously whatever I don't get to in the oral argument, I will rely on the initial and reply briefs. I'll start with the violation of Poole's rights and the jurors' rights under the Batson and Miller L cases. This issue involves 2 African-American jurors, Waring and Blandon. Now, the case law is pretty clear that the state can use a preemptory challenge to challenge a juror who's opposed to the death penalty but short of being Witherspoon Witt excludable. If the juror is against the death penalty, would have equivocates about whether or not they can oppose it in a particular case, or if they have expressed what they call unequivocal discomfort with the death penalty. That did not occur in this case. Jurors Waring and Blandon, like most of the jurors in this case, indicated very clearly that they could and would follow the law in aggravating and mitigating circumstances.
The question that was asked of the jurors was, if you had a choice, if you had an opportunity to vote as to whether we could keep the death penalty or not in the state, how would you vote? Was that question asked of all the jurors or just the African American jurors?
It was asked of some of the first group of jurors, not all. It was
thought
not
all
asked
of
of
the
any of
first
the second group
I
of
thought
jurors.
all of the first group was asked that question.
No, absolutely not. What happened is the prosecutor, when he made the strike, said, I've asked all the jurors that question. Then he caught himself and says, well, no, not all of them, depending on how they were answering my question about how they feel philosophically about the death penalty. So many of the first group of jurors were not asked that question. None of the second group of jurors was asked that question. Or, for that matter, the second group of jurors were not even asked the basic philosophical question about how do you feel about the fact that we have capital punishment or that we can take a life for taking a life.
But that second group of jurors were asked about capital punishment, were
They
they not?
were asked if they could follow the law, and they all, the one who said that he couldn't was excused. All the rest of the eight said that they could, but that's the same thing Waring and Blandon said.
So is your argument that every juror has to be asked the same specific question about the death penalty in order for any strike based on feelings about the death penalty to be a valid strike?
No, I don't think that every juror has to be asked exactly the same questions, but I do think that it's indicative of pretext. I mean, the third prong of Melbourne, which is what we're all agreed that we're on, is whether or not the reason given is under all of the circumstances of the voir dire, whether it's genuine or pretextual.
Well,
I think it's
in order to be pretextual, in my mind, at least you would have to have some of the other jurors who were in fact asked the same question to have answered it the same way, and yet they stayed on the jury. And so my question to you is, those jurors who were asked that question, was there any juror who was not stricken who answered the question the same way that these two jurors did?
No, there was not. But I think that under the Miller L case and Reed versus Quarterman and other cases, that disparate questioning is indicative of pretext, and that's what you have here. I'm not saying that every juror had to be asked the exact same question. What I am saying is this. The prosecutor, first he says, I've asked every juror that question. Then he says, oops, wait a minute, no, I haven't. But I've asked them that question depending on how they replied to my question about how they feel philosophically about the death penalty.
I just want to ask, just as far as the question that was asked, if you would go into the voting booth and vote, how would you vote? There's nothing, so you're not saying that itself would be that was not an improper question?
That's correct. That was
Okay,
not an
because
improper
that's a little
question.
different than what you're feeling, could you impose death? It seems to me that a lot of jurors would answer, I'm not sure whether I'd vote to abolish it. Would have nothing to do with their feelings. But I just want about the...
I don't think that's an improper question.
Okay.
I think that it's, again, indicative of some things that the juror Waring was not allowed to finish her answer. She was cut off in mid-sentence. Just, how if there was this hypothetical referendum, how would you vote? She starts off, I'm not sure, but whatever, and then she gets cut off. That's fine. That's all we need to hear. Now,
And what was the profile of those two jurors that were struck? They were... the judge observed that they were young, and do you have, any issues with regarding the judge sort of supplying the race-neutral reason and then the prosecutor jumping on that reason?
Well, the prosecutor didn't jump on it right away. The first thing that happened is when the judge asked, do you have any other reasons for the strike besides their answer on this capital punishment referendum? And the prosecutor says, no, I don't. Later on, probably 7 or 8 pages later into the voir dire, the judge said, well, I thought you were going to say age. Even then, the prosecutor didn't completely jump on age. He didn't give age as a reason until the following day.
But the prosecutor, for example, I've had the transcript here, juror Waring, 21 years old. And when he asked her, how old are you? She said 21. And the prosecutor asked, how do you feel about being asked to do this job when you're very old enough to vote? So the prosecutor did make inquiries in that area, which may have been why the judge thought that he was going to use that as a
Well,
reason.
right.
It's not
I
like
mean,
the judge came out from the,
But the fact the judge thought he was going to use it, but he didn't use it, the judge said, Mr. Aguero, do you have any other reasons for this challenge other than the one you stated about the death penalty referendum? No, I don't. That couldn't be any clearer. So again, I think now in the Noel case, this court made the point. They talked about age as a possible. Actually, the reasons given in Noel were kind of similar to the reasons here. This court said that the Florida Supreme Court, has never said that age is a good reason for a strike, but noted that some of the DCAs have. But the key here is the fact that you have to go by what the reasons were given. The Assistant State Attorney General says that all the prosecutor was doing here was, let me see if I can find the exact language. Basically, all he was trying to do was impanel a panel of older, mature jurors who could and would impose the death penalty. If
Isn't
that was
what
on
the
his mind.
prosecutor said the next, I believe the next day is when he actually said, yes, these were young people and I've stricken other young people and I'm trying to, and he actually says that he's trying to get a jury of older people.
Next day. But if that was on his mind when he struck jurors Waring and Blandon, what could have been a more golden opportunity to say so then? Do you have any other reasons for these strikes? No, Your Honor, I don't. That's pretty clear.
Well, but we're looking at, I guess the question is that the judge is evaluating the genuineness of the reasons being offered. So going back to the question that the reasons offered was they were uncertain about how they would vote. And I guess we go back to that in this case, with the judge having gone through all the steps and having made findings, where under our case law should we be reaching a different conclusion about what actually happened here?
Well, I think the case law, I mean, the main case that I would cite on this court's case law is Noel. But I think you also have to look at Miller L. and its progeny, which says that you have to look at the entire voir dire and look at the evidence of what the motive, to determine genuineness as opposed to pretext. And what I want to go back to here, there were a lot of differences between who got the how would you vote in this hypothetical referendum question and who didn't get it. But what I think is really crucial is after this is all over, okay, they have the first group of jurors, which is a large group, and they think they've picked 12 jurors and they're just working on the alternate. But then Miss Moore, it turns out, knows the victim's mother and she can't serve on the jury. So now we're back down to 11 and we're picking at least one juror who's actually going to serve on the jury, and possibly as many as all eight, because the defense had only used one preemptory. So we've got this second group of 8 jurors comes up. It's originally 9. One of them gets removed because he was opposed to the death penalty in all circumstances. Now you've got 8. All of a sudden, the prosecutor has lost interest in this question about not only how would you vote in this hypothetical referendum, but even the question, how do you feel philosophically about the fact that we have a law in Florida that allows capital punishment? He didn't ask any of those jurors that question.
What was the makeup of this second group of 8 people? Were these also people who had been in the original jury pool that was asked some of these questions?
I don't believe so. I think I don't believe that they were. They were. No, they were certainly not asked individually these questions.
No, I understand
right.
that, but my question is, was some of these people, and there was a bigger pool than the 11 that had been chosen, and the ones who had been stricken for either cause or peremptorily. And so were some of the people in the 8 also people who had been in the original larger pool?
To the best of my recollection, I would have to say no. I think they might have gotten questions like, are you eligible to serve or whatever. But the reason I say no on the death penalty questions is because with the first larger group, initially the judge asked the Witherspoon-Witt questions. Can you impose it? Are you so for it that you'd automatically vote for, or automatically vote for against? And then that occurred again with the second group of 8. The judge first asked the questions, are there anybody in this group that would not impose the death penalty or would automatically impose the death penalty? And one juror of the second group of 8 was excused for that reason. Then they went to the individual questioning by the prosecutor and then later by the defense attorney. So I think that, again, under the Miller L. case, I think you have to look at the disparate questioning as being indicative of pretext. You have to look at the coming up with an additional reason the next day as being indicative of pretext. And I think most importantly, I mean, the court has made it clear that...
I guess what troubles me about that is the judge actually made his determination under the Melbourne standard the day before. And so now you're telling us that we have to look at his ruling based on what went on the next day, because the next day he says you've all put this on the record and move on. And so it doesn't seem that the trial judge was influenced by the prosecutor's statements the next day.
But he should have been influenced by what happened the next day. And I think that actually goes to something that I think is important to point out here, which is that the state in its brief does not argue any kind of preservation. They basically do not contest preservation in this case. I didn't deal with it in the reply brief because the state didn't raise it. Now, I think what's important here is I was anticipating that the court might say to me, okay, don't we have a problem here when you point to how the prosecutor dealt with the second group of jurors, the disparate questioning? That was not called to the trial judge's attention, and I think my answer to that is what you're talking about. The judge twice assured defense counsel that you've preserved this. You don't need to object again. This is preserved. And I have 5 cases, none of which are cited in either brief, that stand for that proposition that you don't need to object again when you don't need to comply with joiner when the judge has assured you that your objection is preserved. I did not cite any of those cases because the state didn't contest it. But if the court would like, I could file a notice of supplemental authority to, with those cases. But the point is the defense was basically told you don't need to object again. So then going back to Miller L., I think that you have to look at the entire context of the voir dire to determine whether the prosecutor's reasons were genuine or pretextual. Now, I want to get back to the key thing about, I absolutely agree that if these jurors had expressed anything that could be fairly termed opposition to the death penalty, unequivocal discomfort with the death penalty, then my argument would be weaker. But they didn't. Their answers were exemplary. They were asked to rate themselves on a 1 to 10 scale. They rated themselves at a 5, like almost every. There was, I think, 1 4 or 4 and a hand, 1 6, 1 4 and a handful of 6.
But that's not the test. We're not looking at a cause challenge. The issue is whether, and I think that the key, and I'm looking at Noel, is that were jurors similarly situated who were white, were they left on the jury even though they answered the question in a similar manner? And I think your answer was...
The problem is, what I have here is not so much comparative analysis. What I have is disparate questioning. I cannot honestly tell you that any white jurors answered that question in a similar manner, only because they were not asked that question. And that's, again, why I say Miller L. compels reversal in this case.
Well, what were there was a predicate before the fatal question.
The predicate supposedly...
And so I would assume you're saying they've not questioned all of the jurors in the same way. Explain to us, as you see, what was the difference? You're saying there was identical questioning. How about the responses? Were the responses identical?
No, what I'm saying is there wasn't identical questioning.
Just that one question. I mean, the predicate to get to that point, there was not even that.
Even the predicate was not
the same.
identical. It wasn't identical questioning, and it wasn't identical. The second group of jurors was not even asked the predicate. They were not even asked, how do you feel about capital punishment philosophically? How do you feel about the fact that we have a law in this country that allows us to take a life for a life? That was the predicate question that, according to the prosecutor, determined whether you got the referendum question. But the fact is, even among the first group of jurors, there was, for example, the third African-American juror, Ippert, got the referendum question, got with the how would you vote question. Now, she answered it. She didn't say, I don't know, or she didn't hesitate. She just said, I would vote for it. But she got that question her answer to the predicate question was almost identical to the answer that Juror Sims has to the predicate question, and nobody asked Juror Sims the referendum question. So I think, I mean, this gets kind of convoluted, but if you look at the briefs, I think you can see that there was a lot of selective questioning to get these answers. Then when the answers were got, Juror Waring was basically cut off when she was trying to, I mean, I guess she was musing. People don't ordinarily think, how would they vote in a hypothetical referendum? But I think you can look at all of the answers in context by Mr. Blandon, by Ms. Waring, and they were exemplary. I mean, they were exactly the kind of jurors that both sides should want in a death case. They could consider the aggravating and mitigating circumstance. They could recommend death if the aggravators outweighed the mitigators. They could recommend life if the mitigators outweighed the aggravators. The prosecutor asked, could you look at this defendant, Mark Poole, in the eye and tell him that you voted for him to get death? Because if it's a unanimous vote, he'll know it. And they all said yes. They were asked to rate themselves on the scale of 1 to 10, and their answer was 5. So you don't have unequivocal discomfort with the death penalty. You don't have, in the Noel case, for example.
You are in your rebuttal time.
I'm just going to take about 30 seconds more here and now
Take
save
as much
it.
time as you
But
want.
in the Noel case, they talk about that Noel's juror Ortega expressed only mixed feelings about the death penalty. In other words, his answers were exemplary. And I think that there's no lawful basis to conclude that Waring and Blandon were not proper jurors. They did not express any kind of opposition to the death penalty other than an answer that indicates thoughtfulness. I got to think about that. I'm going to sit down now and I'll reserve the rest of my time.
Good morning. Scott Brown on behalf of the state of Florida. I want to clarify one thing initially. Mr. Bulletin is claiming that jurors Blandon and Waring were targeted for questions that were not asked of other members of the panel. Juror Blandon was never asked the targeted or allegedly targeted question. He was not asked by the prosecutor, how would you vote if there were a referendum in the state of Florida tomorrow? How would you vote?
So what question was he asked?
He was asked philosophically, like all the other jurors, how do you feel about the death penalty? Now, Juror Blandon was seated next to Juror Waring. So he said you had asked her this question, and he volunteered. I'm not sure, like her, Juror Waring, how I would vote on it. So the entire factual premise of his argument is incorrect.
But his real premise here is that of however many people that were on this panel, not all of them were asked this question about if you had a referendum, how would you vote? Would you vote to have a death penalty in the state? But as I understood it, a number of people other than Waring and Blandon were. So tell us who was and who wasn't.
Your Honor, there were 4 questions asked by the prosecutor of jurors, Juror Day, Maruska, Waring, and Ippert. 2 were white, 2 were black. That answer, however, was volunteered 7 times.
But I think, though, again, in fairness, if a question is being still targeted and the juror is volunteering, they don't need to ask the question. I mean, it's pretty clear that this was, if you're sitting back as a prosecutor, you've got a black defendant and white victims. So you're, even aside from prejudice, as far as motivation or racial discrimination, it stands to reason that you would prefer not to have, in that situation, you'd rather have white jurors than black jurors. I mean, if we're just being perfectly honest about it, so what you're shaking your head, I mean, the fact is that there were 3 black jurors on this whole panel, and 2 were stricken. So 1 older black male sat, right, and the rest were white jurors.
Female. It was a female, older female.
And the rest were 11 white jurors.
All older, middle-aged, and each of them were perceived by the prosecutor as strong death penalty jurors. Now, I disagree with you. You're saying, well, he didn't have to ask that question. Well, so then you're speculating the prosecutor now must have had a racially discriminatory motive, even though he didn't ask that question of Blandon. Oh, he would have. Really? That's not where the case law sits, Your Honor. It's his burden to prove discrimination and that the strikes were exercised in a discriminatory manner. So you're standing that on its head to say, aha, he would have asked that question. But you know what? He asked that question of white jurors, too. There was no targeted questioning of jurors. And unlike this court's decision in Noel, in that case, the prosecutor's initial reason for strike is I didn't like him. Oh, he's young like the defendant. But you know what you had in Noel, which you don't have here, is you had a comparative white juror of the same age. So the reasons given in Noel were not nearly as strong as the reasons in this case. And you know what? Juror Ippert, who answered the question without hesitation, how would you vote on the death penalty tomorrow? I would vote for it. She sat on the jury. So what the record reflects in this case is a prosecutor who wanted an older, more experienced, and strong death penalty jury. There is no targeted
I guess if the prosecutor at the point where he was asked for his race-neutral reason would have said, they're young and they express this, we probably wouldn't be here on this issue. It's just the way that it was done, and so I agree with you that it looks like that was maybe in the back of his mind that he wanted older jurors. I mean, it makes, rather than somebody 18, 19, not knowing whatever they were, 20, 21, young, very young. So that's, what do you say about that as far as whether the reason is genuine? If the reason really is that I want older jurors, which I guess appellate courts have said would be race-neutral reasons, and we're looking at genuineness, not reasonableness, that is, whether the prosecutor actually had, the reason that he was offering. The fact that he didn't offer it, how do we evaluate that?
Well, Your Honor, I think you can evaluate the totality of the circumstances here. What did the prosecutor want? He struck juror Maruska, who's white, who got the how would you vote tomorrow. It was kind of a loop. At this point, I would vote to keep it in place. But juror Maruska, if memory serves, was 31. When he backstruck juror Maruska, he said young and not strong on the death penalty. So he was using youth to selectively target his panel. And again, it's rather clear. If you look at the panel, would jurors Blandon and Wearing fit in? Aside from race, would they have fit in with the rest of the jurors? No, they wouldn't. Their responses on the death penalty were weaker. Their life experience was truncated. He wanted it.
He says that they made the same kind of, on the general questions about would you vote if the evidence demonstrated whatever, those kinds of questions that those jurors made the same kind of answers. So only the answer to the question about the referendum made them different from the other jurors. Now, is that a correct statement?
No, it's not. And actually, I went through in the state's brief, and there were reasons. The prosecutor started with everybody. He wanted to know your philosophy. And remember, this is a resentencing trial. What's the most important thing that, as a prosecutor you're going to want? You don't have a guilt phase. Can they vote for the death penalty? He asked each and every juror philosophically how you felt. Now, some of the jurors were, I strongly believe in it. He's not going to follow up with a question. I went through each juror's response. There's usually a reason for a follow-up. If they said mixed feelings, you got to follow up, whether you were white or black. Again, the record does not support this notion that only blacks were targeted for questioning. Each juror was trying to get, what are your opinions on the death penalty? If you answered the questions, I'm a supporter of the death penalty, and a strong supporter, you didn't get a follow-up. You didn't need one. And remember, voir dire is a dialogue. If he went down the line and asked the same question the same way of each juror, I think it wouldn't be an effective voir dire. It wouldn't be. And the record completely contradicts the notion that there was targeted questioning in this case.
But what about the fact that what part of the argument is that this was really not an important question to the prosecutor, because the next day when we have the panel of 8 that's being questioned, that question never even came up, and not even any questions about the general feelings on the death penalty?
Well, here's a critical distinction. Now, Mr. Bolton keeps calling this a second group of jurors. Well, you know what? Mr. Aguero thought this panel was only for alternates. They had already selected 12 jurors. Now later, at some point during that day, one juror knew that the mother of victim LW, so you had to select an alternate. But that second group of jurors, they were alternates. And what the judge did, the prosecutor and the defense attorney, before that group of alternate jurors, when they first came in, he said, you're going to get a very shortened version. This is our Cliff Notes version of jury selection because you're alternates. It was clear that this alternate group, and again, he says the second group of jurors, at this point they'd exercised strikes. He thought they had 12, and there was some concern that they'd have to replace one juror. But remember, each and every one of them, not only the prosecutor, but the defense attorney did a greatly truncated version of voir dire for the alternate group. So again, if you look at the totality of the circumstances here, it is abundantly clear that these jurors were not discriminated against and Mr. Poole was not discriminated against because of race.
And what was the point of the prosecutor then on that second day, after the judge had accepted his race-neutral reasons for striking the two black jurors, what was the point of him coming back the next day and say, oh, judge, by the way, these are young people and I don't want young people on my panel? I mean, it seems to me he's now trying to continue to justify his striking of these jurors.
You know what, Your Honor, I think the first reason is perfectly legitimate and it's borne out by the record, but it's also borne out by the practice. And Justice Labarga, you pointed out, the prosecutor focused on age and wearing. He noticed right away, hey, you're pretty young here. You're 21 and 22. Few prosecutors are going to keep a 21-year-old on a capital jury. And I don't think it's a contrived response in that sense, because again, you can't point to a young juror. The youngest one was an African American in her 40s, so I don't think it's contrived in this case. And again, it's not like Noel, where you had a white juror who was of the same age as the peremptorily struck Hispanic juror. So that's not what we have today. And again, I think the burden never leaves this table to prove purposeful discrimination.
If in this case, all of the black jurors had been young and they were all struck, would you have a harder argument? Because I guess I'm sensitive to the issue that age is like race. It's it's what you have at the particular point in time. And this idea that, well, we're going to strike everyone over 60 or we're going to strike everyone under 30 when we encourage, part of this is the right of people to serve on juries, where we encourage jury service, and especially for young people. So what message is that to be stated, and is that a problem? In other words, we have that age is used as a basis to strike jurors from service across the board.
Well, Your Honor, I think that the Supreme Court in, I believe it was Rice, has said that age is an appropriate or genuine reason for a peremptory strike. But, I agree with you, that's an interesting issue. And I'm sure prosecutors grapple with it. Well, is a court going to come down and say later on we can't use age? But I think when you look at life experience, I think that's important on a jury. This is a very weighty decision. And I know we entrust young people with voting and military service, but I think it's a legitimate reason. I would want an experienced jury to evaluate the evidence and render a fair verdict. And I think the case law is abundantly clear that it is a proper reason for a strike. And again, we had a genuine race-neutral reason that was accepted by the trial judge.
But I guess what I was asking, and I combined two questions. If it was that all the panel, the young people were black, hypothetical, and they were all struck, would you have a harder time than showing that there wasn't pretext?
It would be certainly an interesting case, and that's certainly not one that I would want to argue, but age is a legitimate reason, and maybe that would be a problem with the jury pool. And then Mr. Bulletin would come in and say, well, it's a jury pool problem, it's discrimination, and how they're bringing in the people from the local area. But again, I think in this case, it's not even a close question. You defer to the trial judge, and the burden both below and here never leaves this table. And he hasn't come close to showing purposeful discrimination in this case. Thank you.
Rebuttal.
If the prosecutor wanted to know the juror's philosophy on the death penalty, then why did he lose interest on the second day with the second group?
Well, that was, but now would you respond to what Mr. Brown said, which is that he believed these were alternates?
If you read the entire voir dire in sequence, early on, they believed that they were selecting alternates. But before any of the death penalty question occurred, at one point, they have 12 jurors from the first group, and they now say, now we're selecting alternates, right? Nobody's going to backstrike. Yeah, that's where we're at. Then they have the situation with Miss Moore, and she's taken off the jury because she knew the victim's mother, and at that point, we have 11 jurors, and all bets are off. Now we know at least one juror, and possibly 2, 3, 5, 8 are going to come from the second group. And that was known by the time any of the death penalty questioning occurred. They already knew that Moore was gone, and they already knew they weren't just selecting alternates. I also have a question.
Let me ask you this before you move off of that.
Sure.
Was this a truncated voir dire? I mean, were there not as many questions asked of this group of 8 as we had in the original selection of the 11?
That's something I'm wondering about, because Mr. Brown said that they actually told the jurors, you guys are alternates, so we're not going to ask you a lot of questions. I don't remember that, and it would be really weird to be telling people that early in the proceeding, you guys are alternates, especially when, in fact, they knew at that point that at least one of the jurors...
My question really is, when you look at the transcript of it, was it a shorter version of...
It was shorter in
voir
part
dire?
because there were only 8 jurors. It was shorter in part because the prosecutor had lost interest in this whole line of questioning that he had before. And it wasn't just because he thought that these are just alternates, because he knew at least one juror and possibly more than one juror was going to sit on the actual jury. And as it turned out, I think his name was Mr. Harris, turned out to be the jury foreman. He came from the second group. So I think what happened here, I mean, I don't want to accuse Mr. Aguero of being a racist. I don't know him personally, but I know people who know him, and I don't think anybody thinks that. But in line with what Justice Periante was saying, this is a case, it's a black on white crime. The victims were young. Poole was not particularly young, but the victims were young. If anything, younger people might identify with the victims. That was discussed in the Noel case. But this is a case where Poole's family was crucial witnesses in the penalty phase. This is a penalty phase only. He had a very admirable, close-knit family from Houghton, Louisiana. I believe 8 or 9 family members testified.
You're out of time. If you could quickly come to a conclusion.
Okay, I'm just... I'll just say that the judge, on the question of age, the prosecutor was asked, do you have any other reasons at the time of the strike? And he said no. Thank you.
Thank you for your arguments. Next case on our docket is Calis versus State of Florida. You may proceed.
May it please the court. My name is George Burton. I'm here with my colleague Leonard R. Ross on behalf of the appellant, Mr. John Calis. Mr. Calis was found guilty of 2 counts of first-degree murder, 2 counts of attempted first-degree murder, and 1 count of armed burglary with a weapon. The trial court found 6 aggravating factors, 1 statutory mitigating factor, weighed them both, and sentenced him to death. This is his direct appeal. In our brief, we argue that there were several errors made by this trial judge, some I haven't seen in my career before, that we think taint the sentencing process and require that he have a new sentencing hearing. And I will start first with the confession. In this case, Mr. Calis had fled the shooting scene that he had done, and he had fled to Dixie County. And in Dixie County, he was seriously wounded. He was flown to Shands Hospital.
What were his wounds?
The record isn't clear other than he was shot 7 times, is my recollection. He had 7 wounds, and he was flown by helicopter from Dixie County to Shands Hospital. And it was 13 days later that he was even able to be spoken to, as what is in the record. And it was the day before he was to go for his first appearances. So the people from Hernando County came to speak to him. They went to the social worker and asked if Mr. Kalish would speak to them, and Mr. Kalish agreed. They then informed Mr. Kalish of his Miranda rights. He did not waive them specifically. The court found that that wasn't significant because he demonstrated a knowledge of the rights from his long criminal history. In this particular case, though, if you look at the comments he made and you look at the confession, Mr. Kalish was not there. He was not with it.
Well, I mean, there was a full evidentiary finding with regard to experts on each side, and you're asking us to come in and to substitute our view based upon the expert presented by the defendant that he was impaired in place of the expert for the state that said he was not, and the finding by the trial judge.
Absolutely.
I mean that's where we are. I mean, so I mean, how do we accomplish that? I mean, that you're asking us to act as medical experts and to make that judgment with no additional evidence. All we have is what the trial court has.
Well, the standard of review for motions to suppress, you have the ability to do this.
Not findings of fact.
No, but you can apply the law. It's a mixed question of law and fact.
Well, no, but the critical aspect here is factual, and that's whether the condition, whether it was a knowing and intelligent statement. I would take it, and we even have at worst, it seems as though the Davis and Tompkins would indicate that there's an equivocal request. I mean, unless we had a rule that you cannot, take statements under medical circumstances, I mean, that'd be one thing, but I don't believe that, I don't know, is there any law along those lines?
You've hit the crux of the matter, Justice Lewis. Can you do it in a hospital setting? And this court said you can in Escobar, that you can do it, and they relied specifically on the attending nurse who spent 3 days with Mr. Escobar and testified that he had a high tolerance to morphine and testified that he was oriented to time, himself, date, all of that. We don't have that in this case. The social worker, Mr. Johnson, testified that he was not oriented to time, he wasn't oriented to place.
When you say those, is that he was not aware of the day or
Yes.
the month where he was, because
Yes.
apparently he was unconscious when he was taken to Shands, I guess is what the
That's
status
correct,
is.
and I sitting here wondering, how can this court uphold a confession where he doesn't know what date it is, where he is, what his charges are, any of that? And
He had the presence of mind to ask them what he was charged with.
yes, he
Like
did.
he may not know the day, the precise location, which is really quite understandable under the circumstances, but he understands the predicament he is in, and he is concerned about the charges. Isn't that what the record reflects?
I think in volume 13, page 791, 792, he asked, what am I being charged with? And then he replied to that, he said, it's even worth being charged or letting these charges go on. Now, does that show someone who thinks that he's in a predicament? That these charges should go away? That's what it says in the record, and I'm quoting exactly where it is. This person was a career criminal. This person has heard the Miranda rights many times, and that's what the court based its ruling on. But it ignored whether or not this gentleman at the time had the wherewithal to make a knowing, intelligent, voluntary waiver of his
But it
rights.
seems to me, and going back to what Justice Lewis asked, and I understand what you're saying, they don't charge him till after he gives the confession. They certainly had enough to charge him, at the point that they didn't need to question him to charge him. And he's definitely under medication. But if you're asking us to either say you can't be questioned when you're under a certain amount of pain medication, which you're not asking us as a rule of law, what is the rule of law that is being violated here if the judge decides that the expert offered by the state is more credible on the issue of whether he was with it during the during the questioning?
Well, the state expert said he was with it some of the time.
And isn't that, I guess, the question for what you're saying, well, he made these incriminating statements. You're sort of saying in the guilt phase it didn't make any difference. In the penalty phase, it seems that the most significant statement was that he had it out for his sister and the niece because he had been charged and had pled to a felony, and was on felony probation. That's true. So it wasn't, if he had come up with a reason that was then used by the state, which wasn't borne out by the evidence, but that supplies the motive, and there's nothing about that that's not correct. So doesn't that sort of, in terms of this being knowing and voluntary as far as the statements, sort of add to the fact that he had the wherewithal to know why he had gone on the shooting spree?
Well, this court in Copshow and Sylvia both, they have found that where the statutory mitigating factor of an emotional disturbance can trump for CCP. And that trumping was made possible by the confession. It's one thing to say, I'm in an emotional frenzy and I'm going to do this to somebody on the way, and in his confession, saying how he planned it, how he was going to do it, and so forth. It's damning when you want to find whether or not a statutory mitigating circumstance trumps CCP, which it should some of the time.
But in addition to the confession, what does the record show about the evidence about the purchase of the ammunition and all that?
It supports CCP.
Yeah.
Absolutely. It sure does. But you see, his house burns down, he's emotionally distraught, he buys ammunition and goes shoot. Is that a strong CCP argument?
Well, that's a different issue as to whether it's a strong CCP argument. Obviously, this was a pretty disturbed person, and you have, you have that he killed a law enforcement officer, which is a significant aggravator. He kills 2 individuals, and he attempts to kill 2 others. This is one of the most aggravated cases. Surely he was a troubled person, and that came out adequately. But in the scheme of everything, it almost is like, well, his reasoning was twisted, but he was sort of right on. They had ruined his life. His sister and the niece. Sometimes we look at these murders, we go, what could have gone on? Here we sort of know. Now, whether you excuse it as the juror or the judge, that's another question. So I'm not, again, in terms of CCP, which seems like it's there from what he did in advance of the planning, the issue of what he said about why he did it really just supplies a motive. It doesn't really, in itself, is the sole reason that the judge found CCP, was it?
No, but the confession was particularly damning on CCP because it showed that this was a plan thought out for quite a while that had festered from the 2009 conviction that you make reference to. And so with that...
But that's where we go back to that the confession, if he said something that made no sense and the state used it, I could sort of see your point, but he said something which shows he was pretty cognizant of what was going on. Now, maybe I'm not making, you understand what I'm saying? In other words, if he said, I was going to kill them because I thought my sister was having an affair with somebody, and it was totally, there was no evidence of that other reason, but the state used it, you could say, well, he must have been hallucinating. But when he says something that is actually reflective of what occurred, it validates that he was there enough to know why he did it. Does that make sense to what I'm sort of saying to you?
And I'm suggesting just because someone has a lucid interval, because when he was initially questioned, and the state expert conceded this, he said things that made absolutely no sense whatsoever. All right? And the state expert conceded that. But he said, quote, he's doing pretty good for what he's been through. And even though all these things he said made no sense, he did say things that did make sense. And that's exactly what the trial court judge found. He did make some sense. Therefore, let's ignore the question whether it was knowing, involuntarily, intelligently given, because he made some
But you're
sense
not
some
saying,
of the time.
is your argument that the Miranda warnings were not knowing and voluntary because he was in the state, or that the totality of the circumstances support that because he was so heavily sedated and he was in the hospital and he had been seriously wounded, that he couldn't give a voluntary confession regardless of Miranda? Is it the latter?
The latter, absolutely.
And what's I hate to ask you, but I will, what's your best case that supports that this court would look at all those circumstances and make that independent judgment?
Escobar, this court did, and it found that because the credibility of the nurse that testified about how this person had a high tolerance to morphine and was orientated all the way around, that this court then made the ruling that it was knowingly, intelligently given. They made that examination specifically.
Do you find something in Escobar that says that what occurred here is, as a matter of law, renders the statement inadmissible? I'm not seeing it. Help me, point out to me if you would, because I do think Escobar is controlling here, and I'm not, my eyes are not going to that part of the opinion that you're referring to.
Well, the reason the court in Escobar upheld the confession was because there was the battle of the experts like this case, but the nurse, who was disinterested, and I guess in this court's view, made credible testimony that this person made a knowingly, intelligently waiver of his rights because he was high tolerance to morphine and she had observed him for 3 days. And he knew where he was, he knew what date it was.
Well, no, I understand all that. I mean, all that's saying is the reasoning for Escobar, but I don't find the language in Escobar that you apparently are relying on that says that in Escobar, if we had these facts, this is what would favor you. And that's what I'm trying to. What part of Escobar says that?
No, I'm responding to the question: has this court ever looked into that issue?
Okay, so your point is,
this is how the court did it.
Well, Escobar's not controlling in your view because there's different evidence.
That's right. It's distinguishable.
And there's no principle of law announced.
But it means that you do the exercise. You did the exercise in Escobar to make that judgment.
But
that
what
was
we
the question,
say
I believe.
is the court added that when evidence adequately supports two conflicting theories, our duty is to review the record in the light most favorable to the prevailing theory. And I don't see how you can say under this record that if the state hadn't put on anything, but you're asking us to say what the state experts said could not be taken as evidence that the totality of the circumstances rendered this confession unknowing or involuntary.
Well, I guess one way to simplify the equation is if someone doesn't know what day it is or where they are, for example, can they knowingly, intelligently waive their rights?
Well, I thought you said that your argument was not that Miranda wasn't knowingly waived, but that the totality of circumstances showed that the confession was not voluntary, which we haven't. We look in circumstances where they withheld food or water or something. I mean, it seemed to me, and we have it on video, that they were being fairly gentle in the questioning. And wasn't there was there somebody from the hospital present while he was being questioned?
Yes, Mr. Johnson.
So, I mean, if somebody saw that he became, if he started to go, I can't talk, I'm gasping for breath, and they continue to question, I could see that you'd have something to support this idea that this was an oppressive, involuntary question.
I'll make it clear, I'm not arguing that there was coercion here.
Okay.
Not arguing that. I'm arguing that he didn't have the faculties to properly make a judgment as to whether or not.
And one of the things that the judge looked at, and we could look at, is how he appeared on the videotape. What would that be supportive of your argument? If we looked at it, we'd say, "Oh my God, this guy is completely out of it. He's hallucinating." Or
well, he
something
would shut down and close his eyes, and there was conflicting testimony.
But doesn't that? I mean, in a hospital setting, he's on medication. He's on heavy medication, so he may go in and out of of sleep, that still doesn't mean that what he does when he's awake is involuntary.
It's true. It could be a case where it's not, like Escobar. Absolutely right, because that person was totally oriented to what they were doing. This gentleman was not, and that's the distinction. And I believe his confession should have been withheld in this case. And the fact that it was there made CCP such a stronger aggravator that it would overcome the statutory mitigation in this case. And I think it's very harmful for that reason.
You know, it's interesting you say that because it's clear he gets this gun. It's clear from other evidence that he was going to kill some people. And somehow the fact that he thinks that his sister and niece ruined his life, which it sounds like from his perspective, he thought he was innocent and they did ruin his life, almost, and he had his house burned down and all of these other factors, almost goes to sort of feeling like, well, at least, even though it was a horrible reason, he had a reason. If you didn't have that in there, you'd sort of have a guy that just decides he's going to go out and kill people. So how do you see this as actually having aggravated the CCP aggravator with everything else that shows that he was intent on killing people that day?
Because even though there was the extreme emotional statutory mitigation found, there was, by contrast, this explanation in his confession that he had a long-term plan to take her out and wipe out the family line, et cetera, all those statements.
And what did he say to his sister after the killing, the surviving sister?
He said, I took care of business or something to that effect.
And that certainly comes into evidence.
Oh, absolutely.
And he
Absolutely.
targeted, I mean, there's no questions.
Let's move to the next point. I mean, I think that they're not defending it because in good faith, they probably have a hard time defending it. But how about if we remove these two? The other aggravators, we're still left with 4 and significant ones. Why would it not be harmless in this particular case?
A harmless error argument is very strong in this case. There is very strong aggravation. The violent felonies that occurred afterwards are extremely weighty in this case. But you know, you have a process. If it's to mean anything to the judges out there in Florida, you have to say no. You can't do that.
But the question is, you can say no, but does that make it a per se reversible? That's the point. And
Well,
it's not fundamental error. We've already held that, haven't we? I mean,
Yes,
we've crossed
but-
the bridge on most of these.
Yes, but you have a jury that was improperly informed of what the law was by the judge, knowing it was wrong, in my opinion, and then that taints the recommendation that they made. Severely taints it, and you need a new recommendation with the proper instructions.
Well, that would be the circumstances then in any case in which an improper aggravator is submitted to the jury as part of the instructions.
Correct, and not one, but 2, and ones that should not have been. I mean, there's no question they shouldn't have been. And I asked this court to reject the state's attempt to broaden these aggravators with their argument, with the episodic argument in the great risk of harm and death to many, and ignore, well, in the issue of avoid arrest, they specifically admit that what the motivation of Mr. Kalish was in this case. But to...
Well, let me ask you, on that point,
Yes.
the motivation as to his sister, Kathleen, I believe was her name, the revenge motivation was present there. What was the motivation for killing the other three, especially the two who survived, who he didn't even know?
Yes. It seemed that it was a part of the extreme disturbance that he was going to kill anybody and anybody there. It wasn't because they were going to be a witness. I mean,
But
he
didn't
told...
he make some statements even before he carried this out to the effect that he's going to kill everyone who gets in his way, even if it's police officers or something to this effect?
He said that shortly thereafter to Mr. Linville on the phone, I believe. He said that. But before he said, he made a statement even before he went there to the effect, not those words, because he didn't say something specific that someone would call the police and warn them, but he made it clear that he was going to do harm over there. And so it seems like he was one of those people that he had this idea he was going to escape somewhere, but everybody knew it was him that did it. He made no secret of it.
When he went, the time between, I think he killed his sister and one other stranger. It was his niece, actually, who he knew survived. He
Yes.
thought that she was dead. What was the time, what was the sequence? He killed his sister first.
Yes.
What's the time sequence between when he kills his sister and the four shootings?
It was all immediate. Bang, bang,
So-
bang, bang.
Okay, so I guess I agree with you. I don't see how the killing of the other person could have, in his mind, was the sole dominant factor in avoiding arrest. But I want to go back to your argument about the jury having been instructed on aggravators that should not have been instructed on cannot be harmless. And, I've struggled with that post-Ring, that it's, since the jury becomes more important, we have a 12-0 recommendation here. I guess that with the fact that they knew about, the jury knew about the killing of the police officer and him getting, that was a prior violent felony, that he killed more people and seriously injured two others, that he was on, was he on felony probation?
Yes.
The idea that you're going to have CCP, avoider, sort of the things that inherit the crime, I'm struggling with thinking in this situation that it still isn't harmless error beyond a reasonable doubt. That no matter what they hear, the facts are that this is one of the most aggravated crimes that one can imagine.
I will concede to this court that it's a tough call. I mean, really, this is a very aggravated case. And it's a tough call, but the law is there for a reason, and you can't turn your back on it. You can't ignore it.
But we've
and this
never,
judge
I
certainly
guess,
did.
this issue of whether it's harmless error, normally we look at whether the judge would have still imposed death if these other aggravators were taken away, I mean, beyond a reasonable doubt. Do you have a case where we have looked, as a court, specifically at whether the jury would still have recommended death beyond a reasonable doubt if these instructions hadn't been given?
I'm trying to think, maybe Omelius may have been a case, but I would be happy to get back to the court.
Yeah, I don't think there is, because I've sort of looked at that issue myself, and I haven't been in the
For some reason,
majority
Omelius
on-
comes to my mind, but I'd be happy to submit something to the court after this argument on that issue.
Because then it seems to me that in any case where we would determine that there was not sufficient evidence to support an aggravator, we would find ourselves in this position, wouldn't we?
Yes, but I think Dixon, when you look at Dixon where it all came back, and they talk about the 5 steps, that step of the jury making a proper recommendation is one of the steps of Dixon. And that Dixon has kind of been forgotten by everybody. But really, that's how it all started, and that's the framework, and it's certainly being violated here. Certainly is, and I'll reserve my time. Thank you.
Thank you.
May it please the court. My name is Mitch Bishop. I represent the state of Florida in this case, and I'd like to address the issues 1, 2, and 3 in that order. Of course, I'll follow the court's questions wherever they may lead, primarily rely on my brief for the remainder of the issues.
Why don't we get out of the way these last two, avoid
Issues
arrest.
2 and issues 3,
Yeah,
Your
let's
Honor.
just get those, because I'm trying to see, certainly, I mean, you must agree that for the first murder, the sister, he just went out and she was shot just immediately.
May I work backwards in those, sort of?
I'm just ask that
issue
question.
3?
You
Yes,
can answer
sir.
that question.
Yes, sir.
So,
Your Honor,
I mean, how can it be that it's an avoid arrest when he hasn't done anything with regard to that she has knowledge of to avoid arrest?
well, and I would agree with that,
Okay.
Justice
Now
Lewis,
then
that
is
Catherine
my-
Donovan was killed out of
Okay,
revenge.
all right. Now, the second murder, though, did he not have to go look throughout the property for the other people?
And this kind of goes back to a question that Justice Periente asked previously about the sequence of the
Right, I
murders.
mean,
and how
didn't he
that
have to go
went.
across the property? Weren't they in other locations or something on
They
the
were.
property?
He had to walk through, out into a porch and then out into a backyard.
Okay,
So
that's-
as
So
he
why
walked
would
in
he
the
have, so I guess the question would be, he could have left after he killed Catherine.
He could have.
So how would eliminating Patricia as be the dominant motive for her murder if she was in a different place?
When he walks in the house, he shoots Catherine Donovan first, okay, and he shoots her about 3 times. She falls down there in between the kitchen table and the sliding glass door. Then the next victim to get shot is actually Manessa Donovan, the niece, the daughter of Catherine. But Manessa and Deborah Tillotson, the second murder victim, are standing out on that porch, looking in through the glass door at Mr. Calis as he shoots Donovan. So Manessa's next. She's shot several times. She fortunately survives. Deborah Tillotson is after that. The only reason Deborah Tillotson's killed is because she was standing there watching him kill Catherine Donovan.
That we got a guy that is severely disturbed who is taking out everybody on the property. Where is our case law that would support that in a case that doesn't involve a law enforcement officer, that the evidence that the sole or dominant motive has to be avoid arrest, has to be very strong? I just don't see it here.
Well, Justice Periente, I would submit that there was no other motive for him to kill Deborah Tillotson.
It was a senseless act. This is a guy that was going ballistic, and he was going to take out everybody on the property. That was his. There doesn't have to be. We had this yesterday. There hasn't been a motive for somebody to do an awful, horrible thing if they're under. He's killing Catherine for a reason that makes no sense, for revenge. And that's why he's killing, I guess trying to kill Manessa. But he's going to kill whoever's there. It doesn't have to make sense, but I guess we'd be speculating, it seems, that if you say that if there's no other reason you'd kill someone, it has to be to avoid arrest. I don't think we've ever said that.
And I'm not asking the court to jump straight to that conclusion necessarily, but there are a lot of factors at play here, and this court has, and as the case law cited in my brief, this court has found that aggravator through circumstantial evidence. He didn't do anything to conceal his identity. He didn't wear gloves. He didn't wear a mask. He went into a house where he knew he would be readily identifiable by the people who knew him and who he knew, the Donovans. And in fact, the second attempted murder victim, Miss Wilson, Amy Wilson Green, who survived, she did sit in court and identify the defendant. And, so the only reason, the only reason he would have had, based on the circumstances of this case, to have killed Tillotson and tried to kill Miss Wilson would have been to eliminate them as witnesses to the other 2 murders, because he assumed that he was successful in killing Manessa as well. So I would ask the court that the avoid arrest witness elimination aggravator should apply to Deborah Tillotson in this case, based on the circumstances of the facts. If I may turn to the second.
But what about Amy? Wasn't there who was Amy in this scenario?
I'm sorry, Justice Quince. Amy Wilson, she's Amy Wilson Green now, but at the time of the shooting, she was Amy Wilson. She was the second attempted murder victim. She was the 4th person shot in the case. It was Catherine Donovan, then Manessa, then Deborah Tillotson, and then Miss Wilson. And
how many times was Amy shot?
Amy was shot, I believe, 3 times, and Vanessa, I believe, 3 as well. I think it was about 3 shots, approximately 3, 2 to 3 for each.
And both played dead, and that's what.
That's correct.
That's why they're alive today.
That ruse fortunately worked out for them, and he turned his attention elsewhere, and they survived. So.
Now, how about the shooting in the neighborhood?
Certainly, Your Honor,
and that seems to really stretch the risk to the great many people.
And Justice Lewis, I don't know that it does stretch it. And contrary to what my colleague says from opposing counsel, we're not giving up that aggravator. I think one of the things.
Sometimes for credibility, it doesn't hurt to give up.
I mean,
I just don't see where this goes. If a fire, a bomb, but when you're shooting within the confines of a single structure, I don't see the risk to the entire neighborhood.
And I can see where you can see that, Justice Lewis. But I'll kind of start with harmless error, and then I'll work backwards and ask the court to consider a few things.
But I mean, we have to consider the law of Florida whether we're going to apply something like that. So,
first
why don't
of
you
all,
start with the first part?
I'm sorry, Justice.
Why don't you start with the first part? How in the world you can justify that aggravate under these facts?
In this situation, one of the things that's unclear from Johnson that gives us that affirms that rule of 4, that we have to have the victim plus 4 other individuals. It doesn't necessarily tell us when we start counting and when we stop counting. And again, we start counting when he starts shooting Catherine Donovan. She's the first victim. We have 4 people total there. We also have him shooting indiscriminately out in this backyard. And we can see from some of the photographic evidence, one of the best exhibits is State's Exhibit 7 in Volume 8.
Do we know if there were any other people in the backyard?
We know that Amanda Preston-Giacomo, the neighbor who testified, that she and her daughter had been out walking in the street previously.
She asked, was there anyone else in the backyard? I mean, there wasn't a family picnic going on. Like, Sylvia is a good case where there was a risk of harm. This case, the only people he killed 2 of the people, and he injured the 2 others, and he got convicted for all 4 of those crimes. Where's the risk of great harm? I mean, this aggravator is for where you shoot into a crowd or shoot into, again, if this was a family picnic and he came and he just started shooting, and then there were all these people around. But so was there anyone else in the backyard other than the 4 victims that he either shot or killed?
Directly in the Donovan's backyard? No, Justice Barrington. No, Justice Quince. There was not. There is a very strong inference that little 5-year-old girl was outside in a neighboring yard at the time of the shooting, based on the testimony from her mother. So you
would say that anytime someone kills in a neighborhood, that anyone within, 100 feet, 300 feet is at risk of harm, and that's what the aggravator was? This is making this death penalty or this murder more aggravated?
Well, what it does, Justice Parente, is that if you have a defendant who goes on an indiscriminate shooting spree, you have an active shooter, basically, and he's going from place to place, and one room to the next room to a backyard, and he's shooting 1 and 2 and 1 and 2 and 1 and 2. He's and some of them lived, some of them died, like we have in this case. He's essentially created a great risk to many people.
But you see, the problem with that is this is severely aggravated because of that fact. He got charged and convicted of 2 first-degree murder cases and got sentenced to death. And I would, in terms of being a friendly question, this is aggravated enough without trying to take an aggravator that wasn't meant for this situation and fitting it in here. And so I don't see that we've ever applied it like you're saying, which is what your argument would be, is that any multiple shooting cases where you're not intending, where you're trying to kill as many people as possible, that aggravator would apply. Is that what you're saying?
When you have indiscriminate shooting to multiple people, yes, Your Honor. But I'm not asking that it be applied in any shooting case where there are multiple victims. But when
the problem, I think the real problem with this is that, as far as we know in this record, there were no other people within the site of where he was shooting.
in that backyard.
And you can speculate about where the neighbor and her little girl may have been, but there is nothing in this record that indicates that they were anywhere near where he was shooting. And we cannot say that just because there might have been somebody else close by, that this is a risk to other people.
And I wouldn't ask the court to speculate, Justice Quince, but I guess that carries into the next part.
What other?
The other people to count.
Yeah, there's no other people that was on this property that he could have shot.
I guess that ties into the rest of my argument that this crime was not complete until he's in Dixie County laying in his van and they've disarmed him.
So anyone who he may have come near at that point would have made this a great risk of harm?
Well, he engages, again, he gets into a shootout with law enforcement, and we have at least 5 deputies who he's fired at this point. So while he's in flight from this murder.
But that's a separate murder case. That wasn't tried as part of this case.
It wasn't simply out of geographic accident of him crossing into another judicial circuit. If he had been...
Well, but again,
right.
The what ifs, if elephant had wings, maybe it could fly. But I mean, let's be really serious about this. I mean, he wasn't even out in the street.
When he engaged in the shootout,
Right.
At the Donovan house?
He wasn't even out in a public street where there are other homes around.
Not at the Donovan house. He was inside the home and then in the backyard.
And wasn't this a targeted shooting? He targeted 4 people. He killed the 4 people. He had a laser bead that targeted specific people. There were only 4 of them.
He targeted 2 people, Justice Perry. I'd say the Donovan people. And then, again, sticking to my witness elimination to Deborah Tillotson and attempted witness elimination to Amy Wilson, they were shot just because they were there and they had witnessed the other 2 murders. But the target, yes, Justice Perry, were the Donovans. And he did have that laser sight to improve the accuracy of his shots.
I guess it's like this, because what we try to do here is look at the big picture, which, of course, this is a very important case to the state of Florida and to this court. This case is aggravated enough without these aggravators. So
I would agree with that, Justice Perry.
So
yes.
would you address that it's pretty clear to me that the judge would have imposed the death penalty without avoid arrest and creating a great risk of harm? So,
even if we take away the second and third claims here, the avoid arrest aggravator.
Okay, so let's assume that. But what about the argument at some point, and whether it's this point or another case, that the instruction to the jury, by being told that this is one they shall consider, and we don't know if they found it or not, because we don't have the special findings, that they would have, beyond a reasonable doubt, have come up with a death recommendation. How do we have any case law on the effect of the jury instruction on the jury and their recommendation? Most of the time we'll say that the judge would have still imposed the death penalty. Any cases on that?
I would suggest, and I don't have any additional cases than what I've cited in my brief already, Your Honor, and I'm happy to research and supplement with additional authority if the court, if it so pleases the court. But it just kind of goes back to, as Your Honor said previously, this jury heard about, once we got to the penalty phase, the jury found out that Captain Reed was killed in Dixie County, the deputy that was killed there in that shootout. That's aggravation. Then they know about the 2 contemporaneous first-degree murders, and obviously they've just convicted him of that, as well as the 2 contemporaneous attempted murders. They also now are finding out about the aggravated assault with a deadly weapon from 2009 and the other criminal charges that put him on felony probation. They're finding out that he's now on felony probation, and as a condition of that felony probation, he had a no-contact order with Manessa Donovan, one of the victims in this case. And that they've also found him guilty of the burglary, and that he committed these murders during the course of the burglary. So when you take, and by the way, the felony probation, the prior violent felonies, and the burglary are not contested here. So when you have those 3 very strong aggravators, I believe it's still harmless beyond a reasonable doubt. I would agree with you, Justice Parente. We're not sitting here fighting just to fight, okay? And my argument is meant to try to make solid, or help the court make solid law with regard to that.
I'm concerned with what you're saying. and we see this in a lot of cases, why wasn't the analysis that you just made here made at the trial level by the state attorney's office? I mean, why didn't they go through, we got these aggravators, we got these facts, why throw in these questionable aggravators that spending all your time here this morning arguing these things? See, that's what I don't understand.
And I can't speak for the assistant state attorney who represented him or represented the state below as far as what their thought process was, and as well, I can't speak for the trial judge who drafted the order the way he did. Though I wish it would have been a little bit more clear and perhaps separated some of the victims out a little bit and applied it a little differently there. I would agree with you, Justice LaVarga, that would have been helpful and more clear. But
don't mean to shoot the messenger.
I understand. Thank you, sir.
Could you go ahead and address the suppression
Issue 1?
I mean, I really think that's this case. That is probably their significant issue.
Yes, sir. And Mr. Calis his statement was taken from law enforcement on January 27th. That was the day before he was released from the hospital, that he was healthy enough to be released from the hospital and go to his first appearance. So the very next day, he goes out and he appears in court and is formally now informed of his charges. I'll point to the trial court.
Was he also moved to the jail? I mean, he didn't go to first appearance and come back to the hospital. He was actually released from the hospital?
That's our understanding from the record. That's the state's understanding, is that he was at that point released and went to his first appearance.
And didn't need any other hospital treatment after being shot 8 times?
I would assume he needed some additional medical treatment. I would assume that he still continued to receive some type of attention.
They're not actually claiming there was some kind of manipulation as far as the, questioning him the day before, as opposed to, waiting.
And I don't mean to speak for opposing counsel, but I think that my colleague indicated that he finds there was no coercion or any type of, and I don't mean to put
that
words
was
in his
raised
mouth,
as part
no
of the
trickery.
brief. The police coercion was presented as part of the brief. That's understandable because it's part of the argument. It's really the medical condition. Why don't you hit that, address that? He says, here's an individual. They go catch him on the day before, just happenstance, that he's going to appear for his, and will have access to counsel. And they catch him. He's closing his eyes, doesn't know where he is, doesn't know what day it is. Have at that.
As far as his orientation to time and place, again, and I think the court's previously discussed this with my opponent, that he's come out of sedation at this point. He was unconscious at the time he went to the hospital. But if we look at the trial court's findings, and that we do have expert testimony from the state and the defense, and the trial court took note of that. However, the trial court's findings as far as denying the motion to suppress these statements is primarily based on the trial court's perception by watching the video and listening to the audio. And when we watch,
well, if that's the case, then this court could do the same thing.
This court has the video speaks for itself, and this court has the advantage to review those two.
Are you sure you really want the law to be in that area? Or I mean, that seems to me is that you have a strong presumption on the factual findings, and you say he just disregarded what the experts said?
I don't think he disregarded it, Justice Lewis. I think he just didn't have to make a credibility finding. And in fact, Mr. Bufkin, or pharmacist Bufkin, who testified for the defense, indicated that he didn't disagree or dispute the state's expert, the toxicologist, who testified about the effects that the drugs would have had on Mr. Calis. He didn't dispute it. He was just offering sort of a different spin or a different angle on the effect that the various medications can have, more in the totality of the circumstances. But he didn't dispute it and say, no, that the state's expert is wrong and the state's expert's conclusions are based on...
The state expert, though, was, I mean, there's no question that he wasn't oriented. But that's, as Justice Kennedy said, is understandable. He's been in the hospital for a while. I mean, that to me doesn't mean much, but weren't some of his answers just not nonsensical? Like, what was the interchange where he's clearly going to be charged with murder the next day. Yes. And I assume the police know that. So why aren't they saying to him, Mr. Calis, you understand that you're being charged with murder and attempted murder tomorrow. So explain that interchange about the charges where he's saying things that to me show he has no idea he's about to be charged, or that the seriousness of the predicament he's in.
And I don't think that when Mr. Calis is advised of his Miranda rights, first, the law enforcement officers aren't required to tell him exactly what they suspect him of or what they're going to charge him with.
There's no magic situation.
Right.
That's why these cases are mixed questions of fact and law, where this court ultimately makes the decision on voluntariness. You agree with that?
Yes, Your Honor.
And although we defer to the factual findings as to what type of state he was in, we still can look at the totality of circumstance, including the kind of answers he gave. So what about that interchange about the charges?
There is some sort of almost where he just kind of rambles and he just starts to talk. But
So what was it? He said they ask him, you understand you're going to be charged, and he says something about, I think they'll just go away. What was that?
He says, is it even worth letting these charges go on, or what am I being charged with?
Does that, in terms that particular statement is completely out of touch, shows to me a person completely out of touch with reality. If he had any idea that he had killed 2 people or 3 people by then, and including a law enforcement officer, his sister, injured his niece almost fatally, to say, well, I think these charges are just going to go away. What does that say to us?
Well, and I would infer from just watching that video and watching his demeanor that he didn't expect that he was going to actually survive this situation when after his little shootout with law enforcement.
But you said, but that contradicts what you're saying, that this was the day before he was going to be released and arraigned, as if he was ready to, if he hadn't committed a murder, he could have walked out of the hospital by himself and gone on with his life.
And again, I don't think that he is disoriented to the sense that he doesn't even know the severity of what's going on, because when the law enforcement officers start asking him, well, and they ask very open-ended questions. Well, we want to talk to you about what happened. Do you know why you're here? Do you know how you ended up where you are? And then he starts to talk, and I'm coming out of Hernando County, and he starts to talk about the shootout. I raised my gun, or somebody raised their gun at me. I raised mine. And he starts to talk about why he went over to kill his sister and his niece, and he starts to speak very, sometimes even very animated, as the trial court found, that about the facts and the circumstances, and everything makes sense. And as I think Your Honor pointed out previously, a lot of his responses were accurate. They were supported by the rest of the evidence.
So you think here, looking at the video, will help us feel confident in the judge's findings?
I believe that the court will be confident in that, and it's part of the record. It's a supplement to the record, and the court has that at its disposal. And
do you think that he believed that he was questioning whether he was going to live or not?
I just draw that personal inference from watching when he's saying that, is it worth these charges going on? He likely didn't expect that when he started his shootout in Dixie County that he likely didn't expect he was going to live through that.
Does the record indicate whether or not he had spoken with hospital personnel, doctors, to indicate his condition to him or anything?
No indication of any type of suicidal tendencies or anything like that.
That would indicate that he would otherwise be aware of his medical condition?
No, Your Honor, there's not.
So we got to stay away from speculation about
yes,
including that he was well enough that he was not going to need future medical care, because the record's silent on that, isn't it?
It is silent on that, so I don't know exactly what additional care he had.
Let's stay within what the judge had before him.
One of the main things that, as far as the medication that he was on, one of the main problems that the appellant took with the medication he was on during the suppression hearing was the opiate acetaminophen synthetic roxicet that was the pain medication he was prescribed. And even if you take the defense's expert, it was given at a normal dose of anywhere from 5 to 10 milliliters. We can see that in the exhibits to the suppression hearing as well that's in the record. And it was given on a PRN or as needed basis, as he needed it for pain. And based on the pharmacist who testified for the defendant, you can give that medication every 4 hours, and it had not been given for nearly 9 hours.
What did the
before law
pharmacist
enforcement.
say who testified for the defendant?
I'm sorry, Your Honor?
What did that pharmacist say about the medication he was under and whether he was capable of being really lucid?
His opinion was that it distorted his cognitive function, essentially. He didn't have a strict diagnosis, so to speak.
Based on just the one drug, or was it acting in concert with other drugs that he was being administered?
At the time that he was interviewed by law enforcement, he had been given 7 different medications, mostly antibiotics, a hypertension medication, and the pain medication as well. A couple of things that were combining for the same purpose. Like there were 3 different antibiotics that were given. And
well, the pharmacist couldn't have said the antibiotics was going to influence
his primary focus was on that pain medication.
The one
pain medication was the primary focus. He did talk to say that the other medications as a whole, in totality, could have had some effect, but not nearly to the degree, in his opinion, as the pain medication would have had. But again, this pain medication was given on an as-needed basis and hadn't been given for nearly 9 hours by the time law enforcement spoke to him. And when you put that next to the state's expert that testified that a majority of the time his answers were coherent and responsive. Sometimes he did say things that weren't responsive to a question. But one of the things to look at as well during this interview by law enforcement, it's a lot of the defendant talking and a lot of the law enforcement listening. They ask some questions, but they ask very open-ended questions, and they're not feeding him answers. And again, I think they've already indicated that there was no coercion on the part of law enforcement here. And even if this court were to find that this particular statement on January 27th from the hospital shouldn't have been admitted into evidence, and we're looking at it just in terms of the penalty phase and how it applied to CCP, there's ample evidence to suggest that this was CCP even without this statement. He made some of the same statements to Todd Linville, his friend, the night before.
But really, the issue is whether it would be harmless error beyond a reasonable doubt, if it was error.
That's correct. It'd be harmless.
I mean, and they concede in the guilt phase it would be.
It would be they concede that it's harmless error beyond a reasonable doubt in the guilt phase. I would submit that it's harmless even if this court finds that it was improperly admitted. It's harmless error beyond a reasonable doubt in the penalty phase as it applies to CCP, because it's only really one piece of the puzzle that the judge used to find CCP in this case. Some of the same statements about having gotten the guns and the ammunition, and he hated his sister, she ruined his life, and he was going to ruin theirs. He makes those same statements the night before the murders on January 13th to Todd Linville, his friend. He purchased ammunition and additional magazine from the sporting goods store on January 13th. All of that was recovered from his van. He goes target shooting just within hours, so to speak, of the murders on a farm nearby, about 17 minutes away from the Donovan home, and he shoots his weapon. He has that weapon equipped with a laser sighting device to improve the accuracy of his shots. And then he goes over there and carries out his plan. So there's ample evidence to support CCP even without this statement. If there are no further questions, I would ask that the court affirm the convictions and death sentences. Thank you.
Thank you. Rebuttal?
In rebuttal, I would like to say that for many, many years, this court has worked very hard to educate judges, make sure that the state attorneys and defense attorneys that do capital cases and the people that do the appeals are competent and know what they're doing. And after all these efforts for more than 2 decades, you have a sentencing order like this. And yes, it's easy to say with the horrible facts in this case, and they are horrible, that we'll ignore these errors and just say harmless. But I submit that this court has to make a statement and let the trial bench know what is aggravators, what aren't, and there has to be consequences for this kind of work that you have before you. And that's all I have. Thank you.
Thank you for your arguments. The court will be in recess for 10 minutes.
Supreme Court is now in session. Please be seated.
Our last case for the day is Basaltto versus Hialeah Automotive. You may proceed.
Good morning. May it please the court, Tim Blake, representing the petitioners, Roberto Basaltto and his wife, Raquel Gonzalez, husband and wife, respondents below. The trial court, citing the case of American Heritage, stated that the public policy favoring arbitration does not come into play until there has been a threshold determination and made whether there's a valid arbitration agreement and whether a valid arbitration agreement exists. So the trial court, after an evidentiary hearing, made the findings of fact and law that under contract law, basic contract law, there was a failure. There was no meeting of the minds, no mutual consent. And the trial court found that the court would not compel arbitration and would allow it to proceed to a jury trial.
Mr. Blake, are there cases that seem to suggest that even the issue of the existence of the contract ought to be submitted to arbitration? Gone that far yet with all these U.S. Supreme Court cases?
Well,
how do you view the law in that area?
The Seifert case is the seminal, your case, the Supreme Court case that says that the first question the court has to ask is there a valid arbitration agreement, and does a valid arbitration agreement exist? And the Federal Arbitration Act, as well as Seifert, say that the basic determination of whether a contract exists is there a meeting of the minds? Is there mutual
but
consent?
the Seifert case was a tort. Someone who was injured, and as I read the Seifert, it was not rising out of the contractual relationship, but a tort in the nature of a warranty kind of claim or a negligence claim, which was not something that was even controlled by the contract. I mean, is that not a valid distinction, or how do you see that?
That was dealing with the second question in Seifert is the matter arbitratable? And so that's what the court went off on in that decision, and it was a tort case. But the court outlined the basic way that you assess the validity of an arbitration agreement. And you have these three, and all the district courts follow Seifert on that issue, that these three questions are at issue. Now, this entire case just deals with question one, about validity and whether or not under basic common law.
What is the holding in this case that is in conflict with a holding in Seifert?
Okay, that's why we're here.
I understand.
And it's very, very straightforward. The third district in reviewing did not determine the validity of the contract based on contract law, such as duress, meeting of the minds.
But they've left that question open. If I understand what they're doing, and I'll admit it's a little convoluted, but it seems to me that they have left the question of whether there was a valid agreement to arbitrate as an open question that's to be addressed on remand, because of their determination that there are factual determinations that still had to be made by the trial court on that issue.
Well,
isn't that what it says there at the end of the little part about on the motion for rehearing?
We contend that the trial court did make findings of fact, and in fact, the last page.
Okay, I understand.
Okay.
But that's not the question I'm asking. I'm asking what the third district has held here.
Okay, the third district
how that is in conflict with a holding in Seifert.
Went directly to the issue on unconscionability and relied on their Murphy case and said that in order to declare it invalid, you have to have unconscionability, you have to procedural and substantive unconscionability.
But that's not accurate. They recognize that this question about the validity of the agreement to arbitrate and whether there was no agreement to arbitrate is still an open question.
Well,
They don't short circuit that. They don't ignore it. They just say that's still an open question that has to be factually, where there are factual determinations that still have to be made. That's really at the very end of this, the little opinion there on the motion for rehearing, isn't it?
that's partially true, because the third district just ignored Seifert and went right to unconscionability. And before you can get to unconscionability, before you can get to these other issues, you have to deal with whether or not there was a valid agreement existed. Now, in this particular case, it's very interesting, the background. The buyers were senior citizens who could not read or write English. They were recent immigrants from Cuba. He worked at a lathe machine shop and hadn't graduated from elementary school. The wife was a seamstress. They watched Spanish Channel 23, and they saw a car for sale. They went in to buy it. They said that car's not available, and they talked them into buying a more expensive car. And then they got in a big dispute about what the value of the trade-in would be. Now, they knew they couldn't speak English. They knew they didn't understand any of the documents that were before them. And so they attempted to tell them what was in the documents. They voluntarily agreed to explain these documents. But in the evidentiary hearing, it became very apparent to the trial court that the saleswoman, couldn't interpret from the English to the Spanish and had great difficulty explaining anything. Then the F&I manager explained and said something like that you have to give up the right to go before a judge, you have to go before an arbitrator.
But what you're saying is all in the third district opinion. Now, here is, looking at what they've said on rehearing, it's a confusing opinion. It seems to me the trial judge made appropriate findings that would have supported what you're just saying, is that there was no meeting of the minds on an agreement to arbitrate and not need to get to procedural and substantive unconscionability. That's what you're arguing.
Yes.
But if within the four corners of this opinion, how is it apparent when they say on rehearing you can go back and have the judge make findings on whether there's agreement to arbitrate, even though the judge already had made those findings?
Yes,
how is that a misapplication or conflict with Siebert? I think that's, I voted for jurisdiction, but I see that, and it seems like their opinion is just off base. But is it in conflict with Siebert if they're saying go back and make a decision as to whether there was an agreement to arbitrate?
The very, very basis of Seifert is that you cannot compel it if it's invalid and doesn't
I understand,
exist.
but apparently on rehearing they said you are free to go back to the trial court and get that finding. And if you get that finding, which I assume you argued on rehearing, we already had that finding.
We have the judge, the last page.
No question, but we're not here. We can't decide the case unless there's conflict with Siebert. Okay. So the issue is, it's just because the opinion is screwy based on what the judge decided. As we look at the record, it makes essentially makes no sense. That part isn't clear that the judge actually did decide it in the opinion. In other words, it doesn't say, well, the judge found there was no agreement to arbitrate, but we don't care, we're going to skip to procedural unconscionability. That's
the third
the problem
district
that
said
Justice Kennedy was pointing
the
out.
whole issue of procedural unconscionability is part, no meeting of the minds, no mutual consent is part of unconscionability.
What you're arguing, and again, the question is whether it's explicit within the four corners, that they went right to, they equated the no meeting of the minds and put it into the procedural unconscionability box instead of taking the no meeting of minds and applying contract law to say there was no agreement to
Okay,
arbitrate.
the third district was reviewing the trial court order. The trial court order initially based his entire opinion on the fact that there was no valid agreement. And I would like to just point out to you that...
I want you to go to the meaning of what was said on rehearing, because in looking at that, the part where it says, as stated, the trial court found the unconscionability issue to be dispositive. Now, actually, it looked to me like he found that there was no agreement to arbitrate was dispositive, but that's what they say, and found it unnecessary to resolve the testimonial conflict. Because we have reversed in part on the issue of unconscionability, the testimonial conflict is now ripe for the trial court consideration. The buyers, that's you, are free on remand to request a ruling on the claim that the arbitration clause was never mentioned when the contracts were translated and that there was no agreement to arbitrate. Now, again, I appreciate the trial court decided that, but we're dealing with whether, if someone was reading this, they would know that the third district violated Seaford without having the trial court order in front of them.
Well, the third district stated just above that, while the trial court stated that it found the buyers to be very credible, the court did not explicitly resolve the conflicts of testimony in favor of the buyers. That is incorrect.
But
that is absolutely
not, the
incorrect.
fact that it's incorrect is not a basis for conflict.
Well,
you understand? So let's go back to...
Okay, that's the basic opinion in the third district was that unconscionability governs everything, and that you have to have procedural and you have to have substantive, and the court said that whether or not the agreement is valid or not is not important, only
But
unconscionability.
that is inconsistent. What you're saying is not consistent with what it says on the motion for rehearing, what Justice Periani just read to you. Now, I understand that you want to wish that part of it away, but it's there. The third district said it. Now,
all I can do is cite the trial court order, which is part of the record, which is totally inconsistent
but that doesn't
with that.
we don't look at the trial court order to determine whether we have jurisdiction. We look at the face of the opinion from and what the third district has said to determine if what they have said in a holding is in conflict with a holding of some other district court or of ours. And I'm still, the question I started off with, like what's the holding they have here that's in conflict with a holding in Seifert? I still haven't heard that articulated.
They ignored Seifert, period.
But they
altogether. You're saying that the factual issue...
Your argument really, at least it seems to me, that what you are saying is that Seifert would require them to look at whether or not there was a valid arbitration agreement before they went into all the business about procedural and substantive unconscionability.
Yes.
And because they did not do that, even though on rehearing they said you can go and do that it is a violation of Seifert. That's your basic argument.
Yes, Your Honor, and it's a threshold determination. You don't even get to unconscionability if you don't have a valid agreement to enforce. If it doesn't exist, you don't go any farther.
Well, but the reality is, in the legal analysis of those questions, it could be determined that something is unconscionable and you'd never reach the other question. Because you don't need to, if it's unconscionable, on both prongs, you don't need to determine if it may be a more difficult question to decide whether there was a contract.
The point is well taken, Your Honor, but let me explain to you that Judge Cope, in his opinion, in footnote 4, made a very interesting comment citing the case of Steinhardt.
Footnote 4, I think, is where Judge Cope is speaking just for himself.
That's right, he is. And he just says, we should be following Steinhardt, not Murphy. We should be following, in essence, Seifert and not Murphy, because the case of Steinhardt doesn't hold that you need both. It only says that it's an approach and it's not the law, and that what you need to do is take it into consideration because unconscionability is a flexible remedy for the court to enforce justice and not enforce an unconscionable term.
We may, but it's not in conflict at this point with anything this court has said. That is that the statement, and we've had this come up in a federal context of the 11th Circuit case, that having both some degree of procedural and substantive unconscionability is required. So that statement is not in conflict with the decision of this court, is it?
Yes, it is.
What's
This court has never held that you need both
well,
procedural
that's not
and
in
substantive
conflict. If we haven't
unconscionability.
decided the case, there's
Yeah.
no conflict on
This
it.
could be the case. This could be the
If
case.
they had certified a question, it could be the case, but it can't be the case unless there's conflict on a decision of our court. And
Well,
I'm-
isn't really what we're talking about here. The basis for the jurisdiction is misapplication of Seifert, because Seifert instructs that you determine whether you even have an agreement before you even start looking to procedural or substantive unconscionability.
Yes, Your Honor.
I mean, it's really simple, straightforward. That's what this case, the case below does not say that Seifert is bad law or we disagree with Seifert or anything like that, but it's the manner in which they applied the law of this court.
Yes.
And it would require, even though you don't have a contract, that you still address procedural and substantive unconscionability as a matter of course. Isn't that?
Yes,
that
it's
where
an
the-
approach. It's
and-
not the law that you have
And
to have
there
both.
had to be a final judgment before you could have the case below, correct?
Absolutely.
And that final judgment found that there was no contract, I mean, on the face of it.
And the reason why it found
Well, I mean,
no
is that
contract-
correct?
Yes, there were
And
two.
does the court below set forth that this is an appeal of that final judgment? Does the third district say that this is an appeal from that final judgment, seeking
Yes,
review of it?
Yes, absolutely.
And that's a contract that held that there's no an order that held that there's no contract.
Yes.
And yet they went ahead and went off on a tangent of procedural and substantive due process contrary to Seifert.
And even if...
Is that correct?
Yes, Your Honor,
Okay.
absolutely. And the interesting issue here is that there were two arbitration agreements here. There was a one-page standalone, multi-paragraphed arbitration agreement. And then there was this a paragraph lengthy on the back of the retail installments financing contract. There were seven areas of irreconcilable inconsistency. And even when the dealership's employees, if they, explained all of that, they couldn't be making a truthful disclosure to the buyers because there are so many conflicts. They couldn't tell which took place and which governed the arbitration agreement. For example, one of them said, what rules apply? One said the American Arbitration Association rules apply. The other one said, well, whoever elects arbitration gets to pick the rules. And doesn't even say what rules. Could be federal, state. Then there's venue. What's the venue? One says state, one says the Southern District.
You
So
are
these are...
you are in your rebuttal time.
Excuse me.
Good morning. Mark Goldstein for the respondent, Hialeah Automotive. I want to start off by saying what an honor it is to appear before you. I've been practicing 22 years, and this is my first time I've been privileged to be here. With that said, here's what this case is about.
Was there a final judgment entered in the trial court?
There's no final judgment. There was no.
How did the appeal? How'd you get an appeal to the third district?
There's a specific provision in the rules of appellate procedure that allow an appeal for denials of motions to compel arbitration.
So this was simply an interlocutory
Yes,
appeal?
it's correct. It's one of
Okay.
the authorized interlocutory orders that may be appealed under the rules.
Here is the problem, and I certainly ask questions that would indicate that I was concerned about jurisdiction, but it is clear that Seifert says the threshold question is whether there's a valid agreement to arbitrate. On the face of this opinion, it states, the trial court order states, it has long been recognized that in this state, that if one is induced not to read a contract or is here not to obtain outside assistance in reading the contract, and he signs an entirely different paper from what the opposing party has represented that the paper to be, the party so signed is entitled to be relieved of his obligations. Although, if the arbitration was mentioned, it was not mentioned in an understandable way. And then they say, under either analysis, procedural unconscionability was established. Now, what I'm hearing Justice Lewis said, and what I would understand, is when those findings were made, that is enough to show that there was no valid agreement to arbitrate, that you don't need to get to, they put procedural unconscionability in some other category rather than looking at what he what the judge was saying, which is there's no agreement to arbitrate. And doesn't that order appear in the record? What was the third district doing in jumping to procedural unconscionability when the first question was there a valid agreement to arbitrate?
Well, I think the third district, in their second to last opinion.
And I apologize to former Judge Cope for saying it was a screwy opinion. I mean, maybe it was right before he was going to leave or something, the court.
That's a new legal theory. Screwy opinion.
It's still screwy.
It's still screwy.
I believe that the second to last opinion of the third DCA was the correct opinion, the one that found that it was proper to compel arbitration of the monetary claims. And
now, so you're jumping over jurisdiction. If you are, for right now, I don't understand that. I don't understand how there's procedural unconscionability in the entire, this is a contract that is as procedurally unconscionable. I mean, if you accept the trial judge's findings as there could be, where is there substantive unconscionability found as to injunctive relief, but not as to monetary damages? I don't understand that reasoning.
it looked strange to me at first when I saw it, but it actually makes sense if you think about it. And by the way,
You had to convince yourself a few times that
the injunctive relief claim is no longer, it's moot at this point. The dealership's out of business. So I don't know if the court
So they were
wants to-
giving, so that was nice. They were giving the plaintiffs the ability to arbitrate a claim that was moot?
Not at the
I mean,
time.
to go to court on a claim that was moot?
Not at the time. The dealership went out of business in 2009, so I don't believe that it was part of the record at that point in time. But the issue is this.
Well, is that in our record now?
I don't think so.
Well, then, really and truly, so if they're out of business, does it matter if they arbitrate or go to court? They're not going to pay the judgment? Is that what you're...
There's a dealer bond. That's what this case is about. That remains in place. Here's the issue, and here's the logic behind the third district. The actual agreements to arbitrate said that they could not arbitrate because it restricted the arbitrator from writing an opinion, and they said that that was not proper. You can't send something to an arbitrator if there's no ability to write an opinion. But that didn't influence whether they found that the monetary claim should go to be arbitrated. That was the specific reason why they felt that the injunctive relief claim, which...
What about defeating the remedial purpose of FDUPTA?
There are plenty of cases that hold that FDUPTA arbitration and damages and injunctive relief claims both go to arbitration under FDUPTA. There's a ton of cases that say that. What I'd ask the court to look at is the Spring Lake case. It's a recently decided second DCA decision. My esteemed colleague and I disagree. He doesn't like the decision, I do, but I think it sets forth the proper standard in these types of cases. What Spring Lake holds involved a 92-year-old lady with a fourth grade education. The second DCA said, when you sign a contract, it's binding, that's the end of it, contract exists. They also cited to the third DCA's case in the Etienne matter, where the third DCA held that a blind woman was bound to a contract.
Well, in this case, what's your understanding of what the third DCA did with the trial court's ruling that there was not a contract in existence?
My opinion is that the third DCA, in their second to last opinion, not the order clarifying it, held that, in fact, that there was a contract. Otherwise, if you don't find that there was a contract, you don't even get to the unconscionability analysis.
We're not here on the second to last opinion, are we? I mean, it's the final word of the third DCA that we have to look at. We don't go look back at, I mean, that may be what you prefer, but that's not what they did, is it?
And that may be why there's no jurisdiction, because if you just look at that last opinion, you can't readily ascertain a conflict with Seifert.
On remand, didn't the court, on motion for rehearing, remand whether or not there was an agreement to arbitrate? And so the whole issue of whether there's a valid contract or not, or the existence of a contract, just went back to the trial court for determination?
That's my understanding of the last opinion of the third district. That's correct.
That they sent that issue, whether a contract exists or not, back to the trial court?
That's my understanding of the third district's
But
last
the first, but Seibert says the first issue to be decided, which is clear was decided from the portion of the order that I read to you that's in the opinion, was that there was no valid meeting of the minds to arbitrate, that they were given a blank contract, and then it was explained to them in Spanish, and there was no question that they did not speak English, and the people that explained to them didn't even understand arbitration.
The point is that we're rewarding these individuals for going to a dealership, rushing through a transaction. They clearly signed these documents. They clearly, by their signatures, agreed to arbitrate their claims.
Well, throughout legal history and the common law, if I hand you a piece of paper and say, I'd like to have your autograph, and it turns out that you're endorsing a check to me, that's fraudulent inducement, isn't it? I mean, isn't that, and there was never an agreement, so that's not a negotiable instrument, correct? Even though it may appear on its face to be. So
correct, but if Your Honor would, Justice, if you would indulge me, I can read this.
I certainly will.
Here's from page 35 of the hearing transcript. Question to the buyer. When you signed the buyer's order agreement to arbitrate and other documents at the dealership, you knew you were signing a legally binding document? Yes. Nobody at the dealership forced you to sign any of these documents without you having the ability to get someone who knows how to read English to explain anything you wanted to have explained, right? Answer, we could have done that, but since we wanted to buy the car and everything here is in English, we decided to sign it and take it. Question, so you elected to take your chances by signing a document in a language you didn't understand?
But you are now,
Yes.
what you're doing, you may not think this is the best experience after we, no, you
I'm
know,
still
these are
enjoying
all,
myself.
you're still enjoying it. That you're taking findings that the trial court made that they didn't know what they were signing, findings that the third district made, which took procedural unconscionability and basically said the way it was explained to them, there was no way that they would understand it, and now you would be asking us to say, but really read more of this transcript and you'll realize that they don't have clean hands and they really knew what they were doing. Is that what you're suggesting from that portion of the transcript?
I am suggesting that they knowingly and voluntarily signed this agreement, knowing they were signing legal documents.
Now,
I'm
is that
responding to
not
Justice Lewis's question.
is that what you argued in front of the third district?
Amongst many things.
Okay, but the third district disagreed with you.
Not necessarily. They did compel arbitration on the retail installment contract provision. So implicitly, they found the existence of a enforceable contract. Otherwise, they wouldn't have gone into the unconscionability.
And what is your
argument.
what are you then would you do with the last paragraph that Justice Kennedy has pointed out to you, and to your opposing counsel about what could happen on remand?
Well, basically, it goes back to the trial judge. The trial judge makes a determination as to whether there is an enforceable agreement.
But would you, as an officer of the court, and whether we take this case or not, agree that if you read the judge's order, the judge made that determination?
The third district evidently didn't think so.
I'm asking you. You were appealing something because you said no. There's contrary evidence to show that there was a valid agreement to arbitrate. That's what you were trying to get reversal of those findings of fact. And instead, the third district affirmed all the findings of fact.
Now, what I was trying to do is get a reversal basically because I thought that there was an enforceable agreement. And under Spring Lake, second DCA's case, there is.
Because the trial court had held that there was not an enforceable agreement.
Trial court had found the buyers to be more credible on that issue.
And that there was no enforceable agreement to arbitrate.
You couldn't take an appeal unless the trial court had held that.
Well,
there's nothing, I mean, even that issue is not subject. Just because a court will disagree with your argument doesn't give you appellate jurisdiction, even on an interlocutory appeal. A court has to decide something, and in this context, it was that no agreement existed, which required arbitration, so therefore he could not compel arbitration.
There were numerous reasons why the trial court denied the motion to compel arbitration. Amongst them, there was the unconscionability issue and findings regarding...
But wasn't that alternatively? He said there's no agreement, no enforceable agreement. And that's where the analysis stops at that point. You have to cross that hurdle before you jump into conscionability land.
Well, I agree, Justice Perry, with what you're saying, but the issue is not so simple. The issue is the trial judge made an error on that issue, and as my opposing counsel has said, this is a de novo review of these proceedings, and I believe that based on the facts that came out before the trial judge, that the third district, in their second to last opinion, seemed to reject that argument that there was no meeting of the minds. Otherwise, they don't get to the unconscionability
And that's
issue at all.
I guess that's where we get to, because if the third district, this is, so it's a screwy case, right?
Yes.
Okay.
I agree.
Where the trial court erred, in your view, in the trial court's assessment of the evidence. Is that correct?
Trial court erred in their application of the law. The application of the law based on these undisputed facts led the third district to conclude that the retail installment contract arbitration clause was enforceable. That was the holding of the third DCA. My colleague here moved for a rehearing, and in the rehearing they sort of receded from that opinion and said, go back and take this up with the trial judge. But again, I just don't see any conflict with Seifert on this issue. Maybe the third district was wrong, maybe they were right.
But you, I have, in my mind, is saying two different things that are in conflict. You're saying that the third district said that there is no valid contract, yet you agree that the third district says you can go back and litigate that issue of whether there's a valid contract. Which is it? Is there no valid contract? And that's what the third district said. Or did the third district say, you go make that determination someplace else?
There were three separate opinions issued by the third district, and that's sort of why this is convoluted. In the second opinion, the third district said that there was no substantive unconscionability.
Okay, so what do you want this court to say? That there was no valid contract, that the third district said there's no valid contract? Or do you want this court to say that's an issue that should be decided at the trial court level?
Well, one, I think it's an issue to be decided at the trial court level. Once that occurs and it goes back before the third DCA, I can argue many of these legal issues. I opposed jurisdiction in this case. I filed a response to the motion. I didn't believe that there was conflict with Seifert. I still don't. And I still think there's further labor on the part of the lower court to do what it's going to do.
But if we accept your argument that the third district says that there's a valid contract, then what's left to do at the trial court? What are they sending back to the trial court?
That's something that I can't know or think what the third district, why they issued that opinion. I think implicitly in the second opinion, they found that there was a valid and enforceable contract. Otherwise, you don't even get to the unconscionability issue. As Justice Pariente said, this is somewhat convoluted. But I think the take from the third DCA's opinion, at least the second one, is there is a valid contract here. And then Mr. Blake said, well, you know, we don't think there is. And they said, well, okay, go back to the trial court.
Let me ask you this just another way then. As I understand the opinion, they affirmed in part and reversed in part. What were they reversing?
Okay. Really, it's pretty straightforward. The third district, in the second opinion, which is the substantive opinion in this case, held that you could not compel injunctive relief in an arbitration. That aspect had to go before the trial judge. The third district also held that there's two arbitration clauses. One of them, the agreement to arbitrate, was unenforceable, but the other one, in the retail installment sales contract, was enforceable and was not substantively unconscionable. Based on that reasoning, the third district said, go ahead and arbitrate the monetary damages claims. And that was the holding until the last decision of the third district came out. I think, frankly, the second decision of the third district was the correct one, and they should have stuck with that. It sort of didn't make sense, candidly, their last opinion when they sent it back to the trial judge on this issue. I think they got it right in the second opinion.
So in the final analysis, what the third district says is, on the monetary damages, you need to arbitrate, and anything else can go to court.
They did that only because they could, the way the agreement was written, the arbitrator did not have the right to write a written opinion, and they found that that violated Chapter 501 of Florida statutes to confine them that way. That was why they sort of made a split decision, sending the injunctive relief claims to court and the damages claims to the arbitrator.
But there's nothing in Florida law that says you can't have injunctive relief by an arbitration because there's
I
no...
agree. I agree, and I argued that till I was blue in the face, but I lost, and I accept it. And at this point, it doesn't matter for the reasons I mentioned.
The other odd thing about it is by dealing with unconscionability, they're talking about really the validity of the contract, which is explicitly part of the arbitration agreement. So it would seem on the face of the arbitration agreement that should be performed at evaluation in arbitration, not by the court.
Under a lot of the recent U.S. Supreme Court decisions, which gave more authority to arbitrators to decide those types of issues, I would agree.
But that wasn't your argument below.
We didn't get that far.
And isn't that, I mean, again, and it may be that this is trumped, like so many other things, by federal law, but that's why I think the first question was Seifert, still good law?
I believe Seifert is good law.
Didn't Seifert deal with the scope of the arbitration agreement? That's really what it was talking about, right? Whether those tort claims and what was presented there was absolutely part of the scope of the agreement?
I would agree. I don't think...
That had nothing to do with whether or not a contract actually existed or not, right?
Correct, but I don't...
That's what Buckeye check cashing was all about.
Right. Correct.
But Seifert, I mean, the question was it not, whether the contract even covered tort claims?
I think that was one of the issues, yes.
And that there was no agreement to whether you discuss it in terms of scope, or you may have a contract to take money to the bank or polish your car, but if I don't have a contract in existence, then you can't refer to that contract to address the claim, can you? Or has all of our law been turned upside down? That's my first question to Mr. Blake, is that have we gone to the point that no matter what, that arbitrators are supposed to be the place, all you have to do is show a piece of paper that says arbitration in it, and whether somebody signed it or didn't, send it to an arbitrator to decide it.
I would ask the court to carefully look again at the Spring Lake case, the 2013 decision I've cited in my brief. Basically, it says when parties sign a contract, a binding contract exists, whether they understood it or not. There are two exceptions. One, if they were prevented from reading it. There's no evidence in this case they were prevented from reading it.
But if they couldn't read English, I mean, how's that? I don't understand. How does that work? I mean,
good
in
question.
a common sense
Good question. Here's the issue. The issue is who assumes the risk if you don't read the language. I mean, you're creating a slippery slope if you go down there because, for example, the third DCA upheld in the Etienne case against an arbitration clause, held it to be valid in the face of an individual who was blind. Clearly, they couldn't read the agreement. That's number one. Case law in Florida and all of the federal courts is replete that when you sign something, you're bound. It's your problem if you're signing agreements in a foreign language. That's really what I would like the court to take from this, is these people came in recklessly, signed an agreement, they decided they wanted to rush, they decided they want to buy the car that night within a period of 45 minutes, and I would ask the court to affirm the second decision of the third DCA that the monetary claims have to be arbitrated and to specifically apply the Spring Lake standards. Thank you very much.
Thank you.
Still an honor to be here.
Thank you. Rebuttal?
Leave
Yes,
them
Your
smiling.
Honor. If you read the rehearing really close, you'll find out why it's in violation of Seifert. It says, because we have reversed in part on the issue of unconscionability, which is in violation of Seifert. Then he goes on to say, the testimony conflict is now ripe for trial consideration. The court had already made a finding of all the facts in his order. So he's giving the defendants another shot to go back and relitigate the factual issues in the evidentiary hearing. Evidentiary hearing, we took testimony from everybody, live, before the judge, and he got to judge their credibility. And when they said that, that these people knew what they were doing, they were never told that they could go get somebody to help them understand what these documents were. What they got, in fact, was the wrong, incorrect, recognizable interpretation of these agreements by employees who had insufficient knowledge to even explain what was there because there were irrefutable conflicts and they couldn't even understand that. And the judge saw that when the judge asked them, what did you say about it? And when asked if the F&I guy said, did you explain all of the parameters of this long arbitration agreement or any of the terms and conditions? He said, no. All I said was, you don't go to a judge and you have to settle, which is bizarre, you have to settle your case before an arbitrator. Now, they don't know what arbitration is. They both testified, never heard the word before. They testified that the dealership never even said the word, period. And they have no concept of what punitive damages is or class action or anything else. Now, this Holloway case...
Well, but that would be true if it had been in English, wouldn't it? I mean,
yes, technically it would.
Well, and so, but it seems like your argument proves a little bit too much because it means that anybody signing this who doesn't happen to understand anything that's in it can then get out of it. Well, that's not the way it works, I don't think.
Well, that's getting to unconscionability, but the judge ruled as a matter of law early and decisively that it's an invalid and doesn't exist, the contract is not to be enforced. Now, this Holloway case, you have to really look at this case. This is a really bad case. This case says that under our modern economy...
Is it one of ours?
That...
It's the second district.
If there's a meeting of the minds that requires an individual to understand aspects, that standard is gone. The corporate policy now trumps public policy that's been enacted through the arbitration code of the state of Florida by the legislature, signed by the governor. They're saying that no matter how I got your signature on, let me tell you, you're bound. If your name's associated with this contract, you're bound. Whatever happened to duress, undue influence, fraud in the influence? What happened here where there was no valid agreement to begin with? They're asking them to sign things that they're misrepresenting. The People case that I cited in my brief says that they're signing a document they thought said one thing, but they were explained it was something else. That's no meeting of the minds. That's basic contract law. So they're just throwing all of the common law of Florida out, the second district. Just saying, forget it. What's more important is the fact that we got to move the economy along. And our modern economy just can't do with things like meeting of the minds or anything like that. We just got to move on for the benefit of corporate America.
You are out of time. If you could bring it to a conclusion.
What we would ask is that this court reinstate the trial court's decision based on the fact that there is no valid arbitration agreement that exists, so none can be enforced, and should the court so desire, could explain Seifert, question number 1, in a more instructive way to some of our district courts, where it could say, we have issues of public policy, we have issues of formation and of whether or not there's a valid contract, we have issues of as this court said in I think it's Schatz, that the state contract law should govern, and whatever else this court would like to explain to the district courts, because they're all over the case, including unconscionability. Unconscionability seems to be, all the district courts say you need both. And Steinhardt said you don't, but now Steinhardt has cited in all the other district courts that you do need it. In reality, you don't need it. And that was a backup argument that the trial court found. Thank you.
Thank you for your arguments. Court is adjourned.
All rise.